Good morning, everyone, and thanks so much for joining us today for our webinar. I'm Jo Lewis, the MD of Safecall, and with me today I've got Tim Smith, who's Operations Director at Safecall, but more importantly from today's perspective, he's also the person who's responsible for heading up our investigative services. Tim has a 30-year career in the police force, and he was superintendent in charge of policing a large area in the northeast of England. So today he uses the knowledge to help our clients, some of which will have joined us today. So thank you for joining us, to deliver impartial, fair and comprehensive workplace investigations. Alongside Tim, we're also really happy to be joined by Stuart Hughes, who's Head of Group Security and Investigations at the multinational energy company SSE, and also has been responsible for many investigations in the workplace. So there's some interesting conversation going to happen today. Sarah Worth from GB Rail Freight. Some of you may have been aware that she was meant to join us today. Unfortunately, she's had to send her apologies, but we will be more than, we'll have lots to talk about as we are. So today we're going to talk about some of the latest workplace investigation trends, statistics and insights. And we're also going to be talking about the importance of good interview techniques and providing you with some practical advice about how to avoid costly pitfalls in your workplace investigations. I can see that a few of you have already found the public chat, which is great. So if you do have any questions that you want to ask of either of our speakers, please do put them in the chat, and we'll either answer them as we go or we will come to them at the end. We'll try and get through as many as possible, but if we don't get through them all, we'll come back to you after the webinar as well. So I'm going to hand over to Tim now, who's going to take a look at what's been happening with workplace investigations in the last year. Thanks, Tim.
Thanks, Jo. Morning, everyone. Earlier this year, we surveyed over 200 people from organisations across the UK to try and understand the role that investigations play in enabling them to maintain compliance within various workplace legislations. Nearly 7 in 10 said the workplace had conducted at least one investigation in the past year. 29% had conducted more than 5, and 14% stated that their organisation had conducted more than 20 in the last 12 months. These figures highlight the ongoing need for investigations. It's consistent with what we see at Safecall as well. It does raise the question, however, why did a third of organisations that we surveyed have had no investigations at all? It's perhaps not a sign, and it could indicate that there are some hidden issues.
So Tim, do any of these figures come as a particular surprise in your experience?
I think that they're broadly in line with what we see from clients and speaking to clients and at these various webinars and other events that we attend. But I do think it's a little surprising that the amount of places that haven't had a workplace investigation. Now, that may be because of the scale of the investigation. They may only be small, or it could be because they're a perfect organisation. But ladies and gentlemen out there, I'm sure you all recognise that there are very few perfect organisations out there in the world, ourselves included. So, why are places not investigating? Is it perhaps a fear of what might be found? Is it sometimes a lack of skill and competency in this area? Because workplace investigations can be quite complex matters. They may start as something very simple, but they can very rapidly turn into more complex issues, and you do need training and experience to be able to do that. If you're not carrying out investigations, does it say something about perhaps about the culture of your organisation, and what message does that send to staff? Investigations are not something to be feared. Many of the reports that I see within Safecall and when we carry out investigations for clients usually result in positive outcomes in terms of recommendations that are made. There may be organisational recommendations, or there may be recommendations regarding individuals and how behaviours can be amended to become more in line with the expected norm within the workplace. But usually there's a very positive outcome that comes from investigations, at least for the organisation concerned. And especially if you do have a speak-up system of any sort in place, the then you need to have a process that sits behind that, because if you have a process in place for speak up, matters will be raised, and you need to be prepared for when those matters are raised. And an ounce of preparation is worth many kilograms of reaction.
Thanks, Tim. And Stuart, I'm interested to hear whether these findings are consistent with your experience.
Well, I definitely fall into the pot of a non-perfect organisation, as Tim's eloquently put it. We have over 75 investigations a year, but for a bit of context, that equates to an FPR of about 1 to 200. So one investigation per 200 employees per annum. I think we see things under the terms of the 10-80-10 rule, and I think that's a good rule to apply to any organisation of a reasonable size, and that dictates that 10% of your organisation are likely to commit an offence if the opportunity presented itself to them at the material time, and depending on their circumstances. The other 10% will never be victim to that. They won't entertain any prospect of committing wrongdoing within the organisation, depending on the circumstances at the material time. And then there's 80% of individuals who could go either way, depending on the circumstances, the opportunity at the material time. So if you apply that logic, that suggests that there is 90% of your organisation could, if all of the circumstances presented themselves and the opportunity existed, commit some form of offence against your organisation. So that sounds like a very high number, but with the logic that you apply to that, that dictates, as Tim says, that, I was very surprised when you saw these numbers that suggested that there was such a high percentage, in my opinion, of organisations that had never conducted a workplace investigation. That seems very, very high, given the current socioeconomic situation globally. I'm not sure exactly of the context of the poll, whether that was global or whether that was European, UK or otherwise. However, that said, people are people and behaviours are behaviours, regardless of the robustness of your mitigations, your control mechanisms, etc. Opportunity will present itself and it will be taken by individuals.
Yeah, in support of that, Stuart, we know from our benchmarking reports that we do each year that typically 1 in 400 people will make a whistleblowing report, a speak up report through the service that we provide. That varies from people doing, and I hate the expression, but blue collar type work generates more reporting than it does perhaps if you're working in a very regulated office environment, for example. So typically somewhere between 1 in 300 and 1 in 400. So, if you have 400 staff, you're going to have an investigation to do because you're going to have a report.
Yeah, listen, that's really important, Tim. Of course it is. And I think that 1 to 200 FPR that we talk about in SSE is the global picture, if you like. But we operate 7 separate businesses that deal in transmission, distribution, generation of electricity, along with a contracting business. And obviously we've got a corporate function as well. And those FPRs vary really pretty wildly depending on what part of the business that you're in and where the opportunity exists. Of course, large construction projects, multi-billion-pound construction projects and transmission businesses and distribution businesses attract more opportunity. So the FPR can be much higher in those environments, as little as 1 to 80, 1 to 75. However, that said, in highly regulated areas like our trading businesses, that can disappear to maybe 1 to 2,000. Because the regulation, the mitigations that are in place are far stricter. So you're right, there's a huge difference between the various business operating models that exist and what businesses are actually involved in. That said, at an average 1 to 400, yeah, you're expecting, if you've got 400 people, you're going to have an investigation or two.
Thanks,
I've just noticed in the public chat there, Stuart, sorry, Joe, that somebody's asking, what is an FBR, Stuart? Not everyone on the calls from the UK today.
Sorry, it's an FPR, and it's a false positive ratio. And that's the measure of how many cases you receive per number of employees per annum.
Thank you very much. So really interesting points there from both of you, but I'm interested to hear from our viewers. So we're going to put a poll up to ask how many investigations have you conducted in the last 12 months? And we'll see whether that correlates with what we're seeing on the screen or whether it doesn't. And so we'll give you a couple of minutes. Well, not a couple of minutes, a couple of seconds. Coming in thick and fast here. Looks like the vast majority of people are in the 1 to 10. Obviously, it's difficult to know the size of organisations, the people that we've got joining the call today. But interesting to see that there are some, Stuart, to your point, that have none. So that's interesting. And I guess, you know, to the point that was raised earlier, you know, if there's an internal or kind of independent speak up process in place and the business is of a certain size, if you're not receiving any reports, then it's potentially worth looking at how that's being communicated with your staff and whether people are sort of using that system and are aware of it, because ultimately the benefit of hearing about these matters internally means that you're very well aware of what's going on in your organisation, and also you can then investigate appropriately for the best outcome for everybody involved. So quite a high percentage, I would say, there, with 9% having none, although, you know, potentially could be a small organisation. Tim and Stuart, sort of what conclusions do you draw from those results?
For me, initially, I think it's important to define investigation as well, the definition of investigation, what's included in your investigation pot here, because ultimately an investigation for me is a set of questions to establish a truth. That's the kind of the whole raison d'etre for an investigation taking place in the first instance. If you take out the HR environment, for example, where there are grievances and such like that do still require investigation but aren't touching on a public interest disclosure in terms of the Public Interest Disclosure Act or the EU legislation or the Japanese legislation, whatever that may be, our numbers relate to wrongdoing in an almost criminal environment. The majority of these things border on a breach of one of the sets of legislation. So I think defining that is important in terms of your assessment of your numbers. However, that said, still, if this is only criminality, that still suggests that there's underreporting going on within organisations for a whole variety of reasons that we've spoken about on several occasions and that I've been deep in the analysis of for 2 decades now, to understand why people aren't reporting and how you shorten the gap between the length of reporting and so on and so forth. So am I surprised? I'm a wee bit surprised, but that's given our own benchmarking and our own work in terms of this space. But you know, that's SSE specific. Tim, you've got a view across a whole plethora of organisations.
Yeah, I think it leads us nicely on, actually, sorry, Tim, to this next topic, because we know that there's a big push by organisations to encourage their employees to speak up, not just driven by large amounts of legislation in different parts of the world, which lend itself to looking to hear from employees, but also really organisations wanting to improve culture and retain employees and retain, you know, and make sure that employees feel you know, proud to work for the organisations that they work for. And we, as a business, have seen a 16% increase in the number of reports that we received last year. We also had an increase in the number of customers that we're supporting as well, which I think demonstrates that people see this as a really important topic. We expect to see these numbers to increase over the coming years. So Tim, why do you think that then, that we are seeing that some organisations, given kind of these increases in numbers, increase in kind of that focus, why there's still organisations that perhaps aren't conducting those investigations?
I think sometimes it's driven by, well, as an example, normally there's 3 reasons why people would contact ourselves and other similar organisations to carry out investigations. The usual one for ourselves would be where there's an element of independence required in the investigation. The second one is a capacity issue, whereby, for example, some organisations are up against regulatory frameworks and timescales where things have to be done by, and sometimes they may just not have sufficient staff to enable them to carry out those investigations. But more usually it's the competency one, which I think drives this. Do people feel comfortable carrying out an investigation? Do they have the confidence of having done things previously that enables them to do it? Because you can get things very, very wrong if you don't know the fundamentals of what you're doing. The question you have up on the screen there relates to that. How do you decide whether or not to investigate? I think if you get a report, regardless of whether it's an HR grievance matter or criminal or something to do with health and safety or whatever, then these matters are going to be investigated, but perhaps it's the extent to which they're investigated. And some reports that you may receive, you won't be able to investigate because the matter that's put before you, the material that you have, may be so limited that there's nothing really that you can act on. A good system, whether it's an external system by a provider like ourselves or an in-house system, should have some kind of feedback mechanism in there which enables you to go back and to ask them questions, to be able to give you sufficient information to carry out an investigation. But in any event, there's two things really that always strike me with these is, how do you retain that information within an organization? What's your organizational memory like? Because you might get 2 or 3 pieces of information which, connected together, may give you sufficient to triage and carry out an investigation. Back in the police, we would have called these single strands of intelligence. And you need more than one strand of intelligence to be able to do something with it. But you can see what I'm getting at. What's the organizational memory for retaining these? Sometimes these may sit in a whistleblowing pot. They may sit in an HR pot. They may sit in a health and safety pot. How do you draw these things together so that you don't miss things? You'll see repeatedly on raised in the news articles where people refer to there were a number of opportunities missed. Well, sometimes these opportunities are missed at an early stage because information's fallen through the cracks. So even though you might get something that you can't investigate on what you see in front of you, there may be other information within your organisation that help you to support that and to move that forward.
Do you have any sort of real life examples of that, of what Tim's talking about, or any experiences to discuss?
Yeah, I think in terms of deciding whether to investigate or not, for me, everything gets investigated because, as I say, a question is an investigation ultimately, right? A contact is only one side of the story. I think it's really important to recognise that in any contact that's given, in any information or piece of intelligence that you receive, it's only one side of the story, and questions are required to try and balance that out. We have a triage process in place that every contact that comes in, every piece of information that comes in goes through that initial assessment, that triage process, looking at the likelihood of wrongdoing, what is our base opinion on the information that's received initially, the severity of that impact, the risk to the reporter. If an investigation is conducted, a full investigation is conducted, and somebody wishes to remain anonymous, is there a risk to the reporter? Is there a risk to the accused individual as well as part of the process? Is there a risk to the organisation? Is there a risk to the investigator? Is a question that's very often missed in this process. Where you conduct internal investigations at SSE, we will be no different to large organisations across the globe. We have rather significant wrongdoing that takes place in our organisation. That can involve sexual offences, can involve serious assaults, so on and so forth. Not just within the workplace, but within the terms of somebody's employment, something that occurs externally. Therefore, an investigator has to be aware of what they may encounter during the course of an investigation. So we always look after the 4 elements of risk as we assess that through a triage process. And those questions are answered on a lowest impact to highest impact, 5 gradings: lowest, low, medium, high, highest. A bit like the system, clearly, that Safecall have. We follow that process and we answer those questions. And ultimately, that's the start of an investigation for me, because you're establishing the one side of the story and that moves you into the second side of the story. Tim's made a really valid point. Sometimes on contacts, we call them one and done. You get a contact, you get some information, you will never hear from that person again. You won't ever be able to contact them in any way again, and the information they provide is quite simply not enough to conduct an investigation after triage. So you've started an investigation, but you can't move forward. I think it's important to document and record what you're doing in those circumstances in case single pieces of intelligence are subsequently received that allow you to tie that together and perhaps move forward. Where you have 3 pieces of non-entity information, 3 is perhaps enough for you to move forward into a particular environment. So single source of truth is important. Identifying that a contact has only one side of the story. The truth ordinarily lies somewhere in the middle of 2 sides of the story. So you have to ensure that you're carrying out this process, in my opinion, to give you the best platform to move forward with an investigation. That's how we would decide whether or not we move into a full investigation. That also allows us to decide where that investigation will lie, whether that sits in my team because it's criminality, it's a public interest disclosure breach, or whether that's shifted out to an HR environment, for example, the health and safety environment. We have regulatory obligations in SSE where it might be something that's required to be reported to the regulator or to government. That, however, remains on a whistleblowing register or a speak up register, because it's not just public interest disclosures that we'll receive, and it allows us to track them all the way through to closure. And we'll maybe speak a wee bit about closure at some point in the future. So apologies, I've gone on a wee bit there. I'm not sure if I answered the question.
No, it's all relevant stuff, Stuart, absolutely. And it actually leads us quite nicely onto the next topic, which Tim touched upon, which is about kind of whether organisations choose to investigate themselves or whether they would bring in an independent external investigator. And it's interesting. I mean, it doesn't surprise me actually that a lot of matters are investigated internally, and it's probably appropriate to do so in many cases. But there is, there are opportunities and examples where sometimes it is more appropriate to engage with an external party. So Tim, what are we seeing with regards to that in the figures?
Yeah, well, I think this is one of the fundamental questions that you need to address at the outset. Who is going to investigate it? I touched on earlier about the usual 3 reasons that we see for people wanting us to carry out external investigations, and that's overwhelmingly the independence angle that's required. And it is one of the main reasons that people get into trouble when they're stood in front of chairs of employment tribunals trying to explain why you've investigated your best friend. It's a little bit like the police are regularly, for example, criticised, and rightly so, for marking their own homework, so to speak. So because you can carry it, the best investigation in the world needs to carry integrity through it from start to finish. And if that's flawed from the outset by the appointment of someone who it can be accused of that they're not impartial, then that investigation is going to struggle. It's especially going to struggle in cutting through to staff. And that's one of the things that you want to fall out of an investigation, is that the investigation's being fair, transparent, and part of that transparency is about the appointment of the investigator. So sometimes it's better on that basis to go external and use an external investigator, perhaps in association with a subject matter expert from within the organisation. That will help an investigator along. One of the other things you can do is you can use an external investigator in what we call a critical friend role, guiding the investigation from external to the organisation, and really in that role you're looking to check for any bias in an investigation. And these are just methods to make sure that your investigation is fair and transparent. One of the interesting things that we've seen develop with some of our clients is because quite often, for example, someone will cry wolf and say, yeah, but Tim Smith is a good friend with Joe Lewis. He's around the house, they share children's events, they go to each other's barbecues, they went to school together. A really good thing to do with an investigator at the outset is to have the investigator declare whether there are any conflicts of interest with the people or the accused, for want of a better term, involved at the outset. And that declaration can go a long way. Here it stops in its tracks allegations of that there's a conflict of interest and a lack of independence. and it's a good thing to be able to demonstrate at the end of an investigation. Unfortunately, if it ends up in front of a tribunal, for example, that this is something that was examined at the outset, it's documented, it's been addressed, and you put it to bed at an early stage. And I would recommend that as a really positive action that you can do at the outset of an investigation.
Thank you. Yeah, interested to understand whether you use external investigators and what approach you take with regards to that.
So I'm very fortunate in my organisation, my team. We have over 100 years of police investigative and government investigative experience. So from that perspective, we tend to carry out our own internal investigations. That said, critically, we will investigate where the police are also involved. So in those circumstances, we will always liaise with the police to establish that the police will have primacy in any investigation that they undertake. Therefore, we have to understand the rules. We have to understand the boundaries and the impact of an internal investigation on a primacy police investigation. So opening up that dialogue and that contact is really critically important. So we tend to do our investigations internally. However, there are also circumstances where external reporting is absolutely required to the regulator, to the company auditors, for example, whereby we would have to take a step back from that. However, back to the point of triage and back to the point of understanding the side of the story and carrying out that basic investigation, you have to establish what you have and the truth in the matter as best you can before you go external. Otherwise, you would be reporting constantly. There is always a place where it comes to significant serious crime that you have to hit the pause button. You have to consider whether or not you've got the skills and experience internally, whether you have got the legality to conduct that investigation internally, and what is the use of any of your investigation if you haven't conducted it in line with rules and regulations that would make it admissible in a court of law or within an employment tribunal, for example, as Tim's mentioned. If you haven't conducted it in line with requirements, then any of that information and evidence may not be admissible in the first place. So it's really important that you understand what it is that's happening and select investigators really importantly. Tim's right, conflict of interest sits with my department as well. So we've got a direct correlation between the whistleblowing register and the conflict of interest register. So they are checked on a regular basis, along with a declaration from that investigator that there is no conflict with the business unit, with the nature of the allegation, or with the individuals involved in that allegation, whether that's the contact, if known, whether that's the accused, or whether that's actually even any of the witnesses. We look for that complete impartiality. Now, fortunately, with 14,000 odd employees, we've got a depth of a pool, a trained pool in terms of conducting those investigations. But you have to tick all of those boxes. You have to go through that assessment as part of your triage to understand whether or not you've actually got external reporting obligations. For example, the Bribery Act. You have external reporting obligations to report if you have received or if anybody in your organisation has given or offered a bribe. Now, that can't be ignored, that can't be looked over. So do you have a skill set? Do you have an understanding? Are you with the right people within your organisation to track that and flow it through? So I think that's where, if you don't have that experience, the information, the advice, the guidance, and the ability of an external organisation is absolutely critical.
Absolutely, thank you. So, I mean, given that we're seeing, Tim, that 74% of organisations are keeping their investigations internal, what do you think that they should be thinking about when they are undergoing and preparing to do those investigations?
Both Stuart and myself have mentioned triage on a number of occasions, and you'll find all investigators repeatedly mentioning triage, but it's the fundamental process at the outset. And it's not about shaping an investigation towards a desired outcome, but it is being cognizant of where an investigation may go based on the information you have at that point in time. But having successfully and rigorously triaged something, then for me, the next piece in the jigsaw is to have proper terms of reference for the investigator to work to. An example of where that can go horribly wrong. Some years back, we were talking to a client who had hired in one of the big auditing companies. Terms of reference weren't as rigorous as they should have been, and they ended up with a large bill and didn't really get what they had wanted investigated. So you need to set rigorous terms of reference at the outset. Now, that doesn't mean that those terms of reference are set in stone for the duration of the investigation. They should be reviewed at regular intervals. If an investigator finds that they've identified a line of inquiry that's outside of the agreed terms of reference, then you should go back to the sponsor of the investigation. If you're an external investigator, you should go back to the organisation and say, look, we think we need to look at a different location within your organisation. We may need to speak to some people who haven't been identified within the terms of reference and get agreement to do that. External investigators shouldn't be rogue. You need to avoid mission creep, because one of the things investigations have to be is they have to be effective. They have to be proportionate, which is part of that triage process at the outset. You don't need to interview 25 people if the likely outcome of something is a first written warning. You've probably done a lot of unnecessary work there and used a lot of time up that could be better used elsewhere. And that's about keeping it proportionate to the investigation and to the matter at hand. And again, that's where having robust terms of reference, so that you know what you want from the investigator and the investigator knows what's expected of them.
Yeah, I totally agree with that. And I guess that's if you're using an external investigator. I think if you're using an internal investigator, which clearly a large proportion of those people who answered the survey are, I guess one of the key things that needs to be considered is ensuring that those investigators or the people carrying out the investigations are appropriately trained, because ultimately, I know that with many of our clients, they're not in the position that Stuart and his team are in, where they've got sort of dedicated investigations teams, and it's often a manager or somebody internally who's asked to look into a matter. And if people aren't kind of appropriately trained, then clearly problems can arise. So before we kind of move on to the next slide, where we talk about the statistics with regards to training, I'd again be really interested to hear from the audience around, you know, how many of you have, so we're going to put another poll up, how many of you have delivered training to your internal investigators? Don't worry, it is anonymous, so please do let us know, because if you say you don't train them, you're not going to be the only people that will be saying that, but it'll be interesting to see. Thank you. So there's still a couple coming through, but I think again that's really interesting and actually echoes what we're going to be presenting on the next slide with regards to one of the statistics. But if you look at that, so we've got about 23% there who've received some training or lots of training, or you know, and then we've got some of them who, some 38% who, some of the investigators have received training, perhaps some haven't, and then I think that probably the most surprising stat is that 40% haven't had any training. So I'm going to move forward to the next slide, but I'm really interested in Stuart and Tim's views on this. So it echoes actually the information that we found in the survey, which is that less than 40% of those surveyed said that their investigators were fully trained. So I think it's similar to what you've all kind of shared there, and thank you very much for that open sharing. So Stuart, I'm going to come to you first with your thoughts on that.
I'm really surprised. I'm really surprised. I think 40% is there's risk to every organisation that hasn't provided any form of training at all to an employee conducting an investigation into other employees, because ultimately that's what it is. And when you don't have training, my view, my opinion, when you don't have suitable training, is that people don't understand the parameters around an investigation. The clearest distinction between an external legal police-led investigation, and an internal investigation is based on the law, and the fact that balance of probability is the key test on an internal investigation under the terms of employment law, and beyond all reasonable doubt in the UK is the test for a criminal case. That's very, very different, and will lead to a different style of investigation often, and will lead to different conclusions at the result of an investigation in terms of recommendations for further action, for disciplinary hearings, sanctions, the tariff of a sanction, so on and so forth, when you're dealing with it internally. At the end of the day, if you investigate internally and you decide there's external reporting, you have to provide that report to the police in a usable fashion. It has to be admissible evidence. Otherwise, you're asking the police to start from scratch again in a whole investigation, and that wastes your time. It wastes a vast amount of time that would be better dedicated elsewhere, for example, to prevention in the first instance. So I think if there's no training provided, individuals don't have that base understanding of what admissibility is, of the balance of evidence that's required to move to a next stage, and the exposure to the individuals and the organisation. So exposure to the organisation is obvious. You don't get to the root cause of the matter. You don't establish the facts of the matter, and the wrongdoing continues because you haven't been able to get to the bottom of it, and the individuals are still within your organisation. So that's a huge risk. The risk to the company and the investigators are, as Tim's alluded to already, you end up at a tribunal in circumstances where you've not conducted a thorough, balanced, appropriate legal investigation, and the exposure can then be far higher and the costs far higher than the investigation itself. So I am really genuinely surprised at 40%. I find that number very, very high. However, that's probably reflective of the situation where we have such a large percentage of organisations within your poll that are dictating that they haven't conducted any investigations at all. So there's perhaps a biased opinion around why do we need to train investigators if we don't do investigations? If everybody's behaving themselves, we don't need investigators in the first instance. That to me then becomes a critical pot, because that's where you're going to fall over, where you don't have training and you all of a sudden have a case and you don't have any of that skills and experience in terms of what to do. Don't underestimate the amount of damage that you can do with a part investigation that's not legal, and the damage that can be done when you then subsequently realise you have to get an external party in, whether that be a regulator, whether that be the police, whether that be, for example, through Safecall. The damage that you can do by having an untrained start to an investigation could be absolutely significant to the business and to the individuals involved.
I think that you make some really great points there, Stuart, and I think the kind of from a legal perspective and obviously reputational perspective, it's super important to get these things right. But I think as well, a lot of the matters that we see aren't necessarily criminal or very serious matters. There can be sort of general kind of misconduct within the workplace, more HR type matters, and I think it's still hugely important to make sure those are conducted appropriately, because ultimately somebody's raised a report, it's important to them, and it's possibly important to a wider group of individuals as well. So Tim, I don't know what thoughts either about what Stuart said or about that kind of the different matters you would like to raise there with regards to training.
Yeah, I would echo what Stuart said. But I mean, as an organisation, we provide training on people on how to manage and set up investigations. And we see a growing number of clients coming to us who are wanting to get things in place before things happen. It's very difficult to close the gate on it after the horse is bolted and you're already in a tribunal. And, you can be stood in front of a tribunal chair and your organisation may suffer a reputational hit. It may suffer a moderate financial penalty in terms of unfair dismissals. But if you're there with a poorly managed investigation around a whistleblowing matter, then compensation and fines are unlimited. And that certainly helps to focus the mind of people who have training budgets around how they can protect their organisation, protect their staff, protect their organisation's reputation by having properly trained investigators. And we do see a significant appetite for that. Not all organisations have the capacity to have separate investigation bodies. So it can quite often fall as a side of desk activity for a manager, or usually supported by an HR business partner. But it's really valuable for the investigators to be trained. As Stuart says, whether it's criminal or you're gathering evidence that you want to present in a tribunal or perhaps in an internal discipline procedure, you need to be gathering your information properly. You need to be treating people who are giving your information properly. And let's not forget, in all of these things in investigations, there is someone there who is being investigated. And from an HR perspective, we shouldn't forget that person either. I go back to when I mentioned, if you're taking 25 witness statements in an investigation that's about a minor grievance matter, then it's starting to look like a witch hunt. It's starting to looks completely disproportionate, and it starts to look like there's a bias in the investigation, which is something that you need to guard against. So to summarise, we are seeing an increasing uptake from a whole variety of organisations, manufacturing, finance, public authorities, who recognise that if you're going to have somebody carrying out an investigation, it's a really important function to get right, and to get it right, you need some training to support that.
I think, sorry, Joanna, I just wanted to jump in on the back of what Tim said there and be really, really blunt, and make sure that the audience and everybody involved in this understands that there's an accused person at the end of this. And if that accused person has committed wrongdoing, the lack of training of an investigator can lead to significant difficulties in understanding that individual is highly likely to lie to you. There's a risk for an untrained investigator that they tend, not everybody, I agree, but they tend to believe what they've been told. And the cases that we subsequently pick up on occasions that have been investigated within the business come with a dialogue around an absolute belief of the story that had been told by an accused person. People that are accused of crime, people who commit crime, will lie to you, and they'll do their utmost to prevent being caught, detected, disciplined, dismissed. So a lack of training can have a real significant impact and an ability to establish the truth. Not about how you ask questions, not about what questions you actually ask. It's about what you do with those responses and how you prove or disprove. Any investigation is there to prove or disprove the allegation that's been made. And I think that's really important to understand, that you have to look at individuals. You have to have an element of training that allows you to separate truths and untruths, and that will lead to faster, more robust, and safer investigations.
Thanks, Stu. I think that's actually interesting, because we saw in the survey that we did that 57% of respondents said that inconsistent witnesses were a key challenge when undertaking investigations, as well as insufficient evidence. What you're talking about, lack of cooperation and conflict of interest. So, as you're saying there, ultimately, the better trained the individual kind of carrying out that investigation is, obviously the more chance there of getting to the right answer, the right outcome at the end of that. I've just noticed a couple of questions in the chat, which I think we'll take now. So the first question from John is, what is your view on recording investigations other than note taking?
Yeah, I'll take that one first, Stuart.
Yep, sure.
I think it depends upon the nature of the matter that you're investigating. But generally speaking, and this is a subject that crops up regularly, and we've spoken at length with senior legal people. Generally speaking, note taken, where you then agree the content of the interview that's taken place, is seen as the normal, accepted way forward. That may well change as technology improves going forward. Once you start recording can sometimes be seen as a barrier to the interview process itself. if someone is thinking very, very hard about what they're going to say, it can result in them being perhaps less forthcoming than they would be otherwise. A lot of that depends on the skill of the person carrying out the interview, and again, that's a training implication. If you have something digitally recorded, well, then you have it recorded. It's the gold standard, but you then need to start thinking about that needs to be transcribed, as in turned from the digital format into a format that would be usable to make decisions, to put in front of tribunals and panels. You need to work out how you're going to store that, where you're going to store it, how long you're going to keep it. It needs to be stored securely. So there's some technical reasons on one side for not doing it. It is the gold standard, but generally speaking, if you're not investigating a serious matter, like a serious health and safety issue, or a crime of some severity, then I would suggest that note taking is still well accepted as the normal way forward. When you swap notes with people who you've interviewed, sometimes they will come back and there'll be a long list of things that they wished they had said when they were interviewed. And how you deal with that is differently. You can add that to the note and say that that's not the recollection of the interviewer. You may have had a note taker in with you who would be able to confirm that. But it's a fact-finding exercise in investigation, and if this adds to your ability to get to the facts, well, then I don't see that there's any real difficulty in taking it into account, with the caveat that it's not information that was put forward at the time of the initial questioning. Stuart, from your side of things?
Yeah, I agree with what you're saying, Tim. I think in SSE, perhaps it's a reflection of us being set up for a number of years now, conducting investigations in the volume that we do. We record, where possible, all interviews. And we do that on the basis that we do one-to-one. So we don't necessarily have an HR presence, for example, when we're conducting an interview. So where possible, we record. Gold standard, absolutely undisputable version of events, backwards and forwards, that doesn't need any other validation. Yes, you're right, absolutely, it needs transcribed on occasion. Internally, we utilise an audio recording for disciplinary proceedings, but if we have to go external, then yes, a full transcript is required. Where we can't, then yes, there's notes taken. We do not leave that interview until such time as those notes are countersigned by the person being interviewed as well. So they have to have, we ensure they get the opportunity to review those notes, because time and time again, if you don't do that, you get a dispute about what was actually said. And without an audio recording, you don't have that closure. And regardless of the circumstances, regardless of the evidence, that can cause questions to be asked by a disciplinary chair or a tribunal panel about the truth of who's the most accurate here in the recollection of what's happened. So if you can record, my advice is, if you can record because it's indisputable. You have to provide a copy of that recording to the accused individual, and you have to transcribe on occasions. So that there are kind of drawbacks to that, I guess. But if you can't record, then you have to go to note taking as full notes as you possibly can, and do not leave that interview until the interviewee has had the opportunity to review and sign. So you've got a signed copy of what's been said. So there's a gold standard, Tim. I completely agree. Evidentially, it is best. It causes you the least pain. It takes more time because it's got to be transcribed, but it doesn't mean that it has to happen. There is no, there's nothing in employment law that dictates that it has to be recorded. A final point in recording is, where an individual is represented by a union, they do not have the right to record themselves. So we ensure that it's only the company side that records, and that the interviewee is the only person who receives a copy of that recording. If they choose to pass it on to anybody else, if they choose to pass it on to the union representative, that's down to them. But we do not allow the union to conduct those recordings simultaneously to our own.
Really interesting. Thank you very much, Stuart. Another question we've just got through the chat then. If there's any more questions people want to ask before we finish, please do send them through now, because we're not far off being up with time here. But Elise has asked, what if neither party wants to take things formally or aren't raising a grievance? So what if it's, I guess, something that, you know, people aren't keen to take down that route? Tim, I'll ask you that question.
Well, I think as an organisation, you can't unknow what you know. So just because someone decides that they've told you something and it happens quite a lot, but I don't want anything doing about it. Depending on the nature of what you're told, you may have to do something with it, because it could be of such seriousness that an individual's wishes, whilst would be taken into consideration, may not be the overriding deciding factor within that. And again, I go back to what I mentioned earlier on. You see it in when things have been to public inquiries about opportunities that were missed. How many times was Jimmy Savile mentioned in an inquiry? Oh, but I don't want it. It's Jim. I don't want anything. You know, or it's a famous person. We see it time and time again, played large out in the public, and then we get lots and lots of people then coming back subsequently saying, "Oh, well, they did this on this occasion and that on that occasion," and you know, the BBC and others have found themselves in a whole world of pain where they haven't investigated. Or, again, I'll refer to something I mentioned earlier, where there isn't that organisational memory, that system of being able to look at something and think, well, this is the third time that Tim's been mentioned in something. We really need to have a look at that. And there may be other means of being able to investigate it other than using the initial person that comes forward. Doesn't mean you have to act on everything. That could drive you insane. But you need to judge what is being reported to me. And if it's something serious, you can't forget something that you've been told just because it's convenient or it's difficult to investigate.
Thanks, Tim. Just conscious that we're going to wrap up shortly. So Stuart, Tim, any sort of final thoughts that you want to share with the audience in general around any of the topics that we've covered today? Stuart, I'll ask you that question first.
Yeah, it's an interesting topic. It's an interesting subject matter. My experience on this has been that I've fallen over quite often in terms of building up the company's speak up policy and procedure, and all of the learnings that have allowed us to get to the position that we're in today. I'm an open book. I'm more than happy to be contacted directly by anybody who wishes to discuss matters further, if I can offer advice and guidance on how we've got to where we are, and indeed what I can learn back from individuals of their own experiences. I think the environment is changing in terms of speak up and whistleblowing. The legislation is helping drive that, of course, but more and more organisations are taking their obligations more seriously and are looking to learn and are looking to build up best practice. There's a lot of resource out there to enable you to do so. It's a scary topic, but it's really rather easy to fix in terms of getting your structure right. You won't stop wrongdoing, but that's a whole other seminar about trying to prevent wrongdoing and etc. Recognising that it happens, but recognising how you respond. If you've got that part right, then actually it's much more comfortable. It can still get uncomfortable, but it's much more comfortable. So I think if you find yourself as one of the organisations that hasn't had any training, that isn't doing investigations, and is worried about how do you put all this together, then there's loads of resource out there. And we're more than happy to have conversations and to guide. And it's not as difficult and daunting as it might seem from a conversation like this today. I appreciate we see ourselves as SMEs in this environment, and you guys are obviously engaging with a huge number of organisations, so we're getting an even broader picture in industry. But it's not as hard as we've perhaps made it sound. So reach out and get it right before something happens would be my advice.
Great, thanks, Stuart. I'm sure you will get some people reaching out to you as a result of this webinar. Tim, any final thoughts from you?
Yeah, it's a little bit like an estate agent. It's not location. It's training. Identify the right people, get them the skills that they need, and that's the best way to protect your organisation. Most grievances and other stuff, you're looking for the facts, and you're looking for them on a balance of probabilities, and with some training and some guidance, your investigations will stand future scrutiny, because one of the things you need to identify at the outset is, well, what's the likelihood of this ending up somewhere where it's very uncomfortable standing in front of judges and tribunal chairs, even when you're 100% certain about what it is that you've been involved with. It's still an uncomfortable position to be in, and with the training to support that, it gives you the confidence to represent the investigation that you've carried out and your organisation and the people who you've investigated, to represent them in a good, positive way.
Thank you, Tim. Well, that's all we've got time for today. So I just want to thank everyone again who's joined us. I hope you've all found it useful. If you would like any support with your investigations or talk to us about training, then do get in touch. And we can also share Stuart's contact details for those of you who want to get in touch with Stuart. So with that said, enjoy the rest of your day, and we'll look forward to seeing you at the next webinar. Thank you.
Thanks, guys.
Thank you.